saved your presentation from the last time you were here.
I'm sorry, what was that?
I say I've saved your presentation on the front file. Very good.
You can probably throw that one out, it's probably out.
Very good presentation.
Okay. Well, today I'm here to talk about computer implemented inventions. Now, I'm expecting to speak about an hour. So in that hour,
That's the laser, don't look
okay. This is forward, and where do I direct it for?
Well,
Where's the receiver?
here, it's RF, so
Yeah, so
you can go forward or backward, you can be pointed at the audience, except when you're using it as a pointer and the laser
Oh, yeah,
comes out.
didn't I point it? Didn't I do the right thing? Okay, I must have just.
If you hear it pointing, then it must mean that you're going in the wrong direction or something.
See, here I am again.
You gotta try the other one.
Oh, I've been going backwards. Okay.
Correct.
Okay. Computer implemented inventions for
And
about
what were your degrees?
computer science and electrical engineering.
So do you have an extra one?
Yeah, right here. And are you recording this?
Yes, it's recording now.
Audio and video?
Yeah, I'm doing a screencast,
Okay,
so it's recording this,
that's fine.
everything but your
Let me just get
face.
past the first few pages here. This is who I am. I am not your attorney. That's what this disclaimer is about. And I'm going to get right into what we're talking about. As I said, this is going to be roughly an hour lecture, so we're not going to go into great depth about computer implemented inventions or patentability. But rather what I want to do is give you an overview of the history as to how the field has evolved, the field of patentability has evolved to where it is today. Many of you may have heard, just generically speaking or generally speaking, that it's difficult to get a patent on a computer implemented invention, or difficult to get a patent on an invention that's implemented in software. We have a question already. Yes, sir.
Could you give me an example of a computer implemented inventions?
More specifically, what I'll be talking about is inventions that are implemented in software.
In definition, what does it mean?
I'm sorry?
And please give the definitions. What does it mean? Computer
For purposes of this lecture, I'll be talking about an invention that is implemented in software. Where, for example, here I'll illustrate in space here, if this is a computer with a processor and a memory and a module inside that memory, the invention is embodied in that module within the memory. Examples would be like an app for an iPhone or a module inside of a large server. Okay?
This is clear.
All right, and I'm specifically talking now about the invention being embodied in the software. Okay, so that I'm under the impression that most of the people here have some experience with patents, some, and so I'm going to be talking to you as if you have some experience. All right, not necessarily a lot, but enough to understand that patent, when issued, has a patent claim to an invention. And when I say computer implemented invention, I mean that patent claim is describing an operation that's taking place in the memory of the computer. All right? So, just generally, for patentability, for anything, for any invention to be patentable, there are several requirements. The main three requirements, at least for purposes of this conversation, are that the subject matter of the invention must qualify as something called statutory subject matter. And that's defined generally under a statute referred to as 35 USC 101. USC stands for US Code. Additionally, for patentability, the invention or the claimed invention must be novel, as defined in 35 USC 102, and non-obvious. Now, most of you are probably familiar with the criteria of novelty and non-obviousness. And I say by most of you, I mean, again, because I believe that most of you have some experience with patents. Today's lecture regards the first of these three criteria, the statutory subject matter. That's our problem, or the problem that we're going to discuss today. Next slide on page 5. Statutory subject matter under 35 USC 101 reads, and I'm going to read it, and note that I have emboldened some of the language. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, therefore, subject to the conditions and requirements of this title. So it's these emboldened words, process, machine, manufacture, and composition of matter, that generally define statutory subject matter. And I use a mnemonic to remember them myself and to encourage others to use this mnemonic to remember what the statutory classes are. I call it the 4 M's. The 4 M's are illustrated down below. Method, machine, item of manufacture, and material. So the 4 M's. On the right side here, I give examples of what each of the M's is. An example of a method would be a method of purifying water. But for purposes of computer-implemented inventions, a method is also the operations that are performed by a computer. Machine, an example is a bicycle. But for purposes of this lecture, a computer is also a machine. Items of manufacture. Example, a hammer is an item of manufacture, a tool. It's a tool that is not a machine per se. But for purposes of this lecture, and for computer-implemented inventions, an item of manufacture is, by way of example, is a storage device that has a program thereon, a program for controlling the operation of a processor. And finally, the 4th M is a material, an example being a chemical composition. On the next slide, slide number 6, although there are those 4 M's, oh, hello to the people that just walked in. I've got some handouts here. You haven't missed anything, I'm just getting started. Okay. Come on, we're being recorded, so I can't chat. Thanks for coming in. Okay. Now, although those 4 M's exist, there are, or there has developed over time, several exceptions to those 4 M's. Meaning, when something happens to be, and the exceptions I'll state, are a law of nature, natural phenomenon, or an abstract idea. Or more, there are various ways that these are described, but these are known as judicial exceptions because historically, over time, through cases that have been heard by the courts, and in particular the U.S. Supreme Court, the courts have found that certain discoveries or inventions just are not eligible for patentability. So, for example, when Einstein derived or recognized or somehow determined the formula E equals mc squared, it's a very important discovery on his part, but that formula could not be patented. He could not obtain a patent on the activity of measuring energy as a function of mass and the speed of light. Examples of natural phenomenon are, for example, a naturally occurring mineral or a naturally occurring plant. So things like that cannot be patented. For purposes of this lecture, the main topic that we're going to be discussing with regard to the judicial exceptions is that of an abstract idea. Abstract ideas are not eligible for patentability. Examples of abstract ideas are mathematical algorithm, even by way of example, E equals mc squared, or the one that I'm going to be stressing this evening is a method that can be performed in the mind of a human being. For example, an algorithm for calculating investment risk. Now, you may think my example there, an algorithm for calculating investment risk, might sound like the kind of thing that a human being would not be capable of doing in their mind. And that's why this phrase here, a method that could be performed in the mind of a human being, is not to be taken literally. And the example I use is make believe you're a human being with a really, really big head. So I call it my big head theory. And if a being or an entity with a big head could perform the method in that big head, then ordinarily that method would be recognized as being an abstract idea and therefore not qualifying as patentable subject matter. And I have to admit, this is a slide that I had from another presentation. So I have that leftover thing down the bottom. Another statutory exception is tax strategies. Has nothing to do with this lecture today, but just in case you're interested, working on, as you mentioned earlier, tax strategies are not patentable subject matter.
I'm sorry.
Yes, go right ahead.
But the
In
big
fact,
theory-
let me just say, I'm encouraging questions. Okay,
Okay.
The presentation I have here is more of an outline rather than a strict lecture. So, what can I do for you?
Well, for example, they have programs that calculate the structural stresses and things.
Mm-hmm.
And they do very easy stuff, but they do billions of calculations in seconds.
That's right.
So theory has it, if I had a big enough head,
Mhm.
I could do all that, and therefore that would not be patentable,
That
even though it's not possible for a human to actually do
is
it.
correct. The way you've described it, the way you've said the fact pattern that you've described would be non-patentable, not eligible for patentability. Yes, John?
So Watson and artificial intelligence, AI, expert systems, subject matter.
It's too broad a question. I cannot definitively say that Watson or any of the processes that are being performed therein are not patentable subject matter. But hold on to that, and maybe we can discuss it as this goes on, and this being lecture. And even by the end of this lecture, you'll recognize that there are gray areas, okay? And this is still an evolving area of the law. I mean, and I'll make that point again, that for all of the things or several of the cases that I'm going to talk about tonight, there were parties on both sides of the table. Some saying something should be patentable, on the other side saying it shouldn't be patentable. So lots of money, lots of time, lots of energy went into the evolution of this law, and it is still evolving. So when you come to me with a particular question like that, is Watson, does it have anything patentable in it? I don't know. I really don't know. But we can still apply the tests that I'm going to show you here today, and we can discuss it. Another question, please.
Big head, computer, same or different?
Big head is the processor in the computer, okay? So ordinarily, and there will be exceptions, in fact, when we get to the test that I'm going to show you later on. I'm using the idea of big head to mean a human being with a really big head, but by analogy, that is also a machine that is capable of performing algorithms or operations similarly to the idea of a person thinking about.
So more same than different.
I'm sorry, I didn't hear?
More same than different.
Perhaps, yes. I don't mind the questions, but you'll have if I'm not quick enough to recognize that a head is a computer or same or different. It's just because I haven't thought about it before. Okay. Yes.
Rather than saying bad, a big head, maybe you could say a normal human being with an infinite amount of time could accomplish this algorithm.
That is also true. That's another way of looking at it. And another analogy that the U.S. Patent and Trademark Office uses is a human being with a pad and paper. So they don't have to have an infinite memory or infinite time necessarily. But yes, infinite time to address your point. In a situation where there are large databases and billions of records and quadrillions of calculations, yes, a human being could not.
But in theory, if he had forever to do it, he could work
Yes,
with.
because keep in mind that what we are talking about is the patentability of the method, the inventive concept, not the rate at which a human being can do that. It's not, we're saying that. So it's not true that just because something is super complex and requires super complex calculations and lots of memory and lots of data accesses that a human being could not possibly perform, that does not mean that it's patentable, because it's not necessarily an inventive concept, or more specifically, it might be deemed an abstract idea. or a mathematical algorithm, or just an algorithm with nothing more. Okay? Yes, sir.
When you, so to speak, apply for your patent, is this test done up front or is this on the hindsight before they issue it?
Both. Okay? Both. But now, today, it's done up front. Okay? But even if a patent is challenged, it may be challenged on some of the grounds that we're going to discuss this evening. Okay?
Can you give?
Yes.
Can you give the definition of abstract idea? How to move from
That
abstract
is
idea
an excellent question, and that is the question that the U.S. Supreme Court is still toying with after about a decade now, maybe even more than a decade, and that is a question that patent attorneys and patent examiners are debating on a daily basis. And we're trying to refine what the abstract idea is. And I'm not going to give you a specific definition, but rather the way that the industry is looking at it is based on cases that have been settled by the courts. And if you have an invention that is similar to cases that the courts have deemed ineligible for patentability, then the argument is that your invention is more likely not patent eligible. Whereas in contrast, if your invention is similar to cases or inventions in cases that have been settled where the courts have found that the subject matter is patentable or patent eligible, then your invention leans towards being more likely patent eligible. So it's still a gray zone that will be argued back and forth. But you can hold on to your question, but let me get through this because there is a flow chart we'll go through where we'll discuss that topic a little bit more. Yes,
John,
Jason.
thank you for. Let's say in a calculation, for example, for a nonlinear, fixed point, the mathematicians come up with numerical analysis, come up with algorithm, how to get an iterative process that is convergent to converge to a fixed point.
Mm-hmm.
Then the IBM, developed software, implemented algorithms in the, let's say, the old days, the 360, to calculate that.
Mm-hmm.
So are you primarily to discuss, at the numerical analysis from just a pure algorithmic point of view to that the implementation of that algorithms on the computer?
Okay, is there a question in there somewhere?
Yeah, the question is that if that algorithm implemented on a piece of computer, is that patentable?
No.
Okay.
If it's just a mathematical algorithm,
But implementation
sure, you're going to put in some numbers, the mathematical algorithm is going to churn around
in a computer.
and then a number is going to come out.
Right, solution come out.
Right, that
Not
would be,
complicated.
you'll see in one of my further examples here, in probably a page or two, that mathematical algorithms are not patentable subject matters.
Thank you.
I have to ask this and maybe it's all, but that program, code that you wrote to do all that,
Covered by
it's
copyright.
copyrightable.
Covered by copyright,
Right.
yes.
Not,
Okay,
not yet.
so it's not that you wouldn't be eligible for some protection, some intellectual property protection, but the method of protection or manner would be copyright law rather than
Definitely.
patent law.
Yeah, the code is
Copyright.
patentable.
Yeah.
How about the
No,
algorithm?
the
How
code
is
is-
the algorithm?
Did you just say the code is patentable?
No. It's copyrightable.
Yes, it can be.
The code.
In fact, it is copyrighted as soon as you write it.
Yeah, but the
As soon as
algorithm
you-
could be patentable too. Right? But
Yeah, you know what,
copyrightable.
Jason, let me get through.
Sure.
In fact,
Thank you.
as far as these specific questions go,
Yes.
and I don't mind them, I'd like to try to get through the lecture
Yeah.
first,
Yeah.
and then we can try to work our way through the more specific questions, okay? So, here I am. Now, this is just a restatement of the 4 M's
Right.
that in the last couple of slides. Okay, patentable subject matter, there are the 4 M's shown: method, machine, item, manufacturer, material. And by the way, for those who are listening to the lecture, this is I'm on sheet number 7. And the judicial exceptions down below, law of nature, natural phenomenon, and abstract idea. And you'll notice I have this dashed line here. For the last few minutes, we've generally been talking about an idea, the big head theory, okay, as I call it. By the way, that's my own language. Nobody else calls it that as far as I know.
Is that patentable?
No, trademark perhaps, okay? Could be a trademark, but anyway, judicial exceptions, you can probably instinctively understand how an abstract idea, a mathematical algorithm, those things that you could do in your head, yeah, that falls under the heading of a method. It's a method of doing something, a method of analyzing numbers that converge and you get an output of a number, okay? I've drawn this dashed lines from judicial exceptions up to machine and item of manufacture because I'm now going to kind of jump around and it's because I expect that most of the people here have some experience with patents, all right? And so let's say you have a patent claim that starts with the phrase, a method comprising. You would say, hey, it's a method that qualifies as patentable subject matter. Why are we having this conversation any further, okay? Or a machine comprising. We'd say, hey, that qualifies as patentable subject matter under a statute, 35 U.S.C. 101. Similarly, an item of manufacture comprising something, okay? You would say, hey, that qualifies as patentable subject matter. Well, the courts have also found situations, at least in the sense of computer-implemented inventions, where even though you might have your algorithm, I'm going to use the example of an algorithm, a mathematical algorithm, which I'm telling you is not patent eligible. And so if you have a program that all it does is churn some numbers and put out another number, okay, it's not patentable subject matter. And by merely putting it on a computer, and thereby saying, hey, I have a machine that does that, that does not get you over the hurdle, okay? And merely putting it onto a storage device, such as a CD-ROM, okay? And saying, I have a tangible product here with program code on it that controls a computer, all right? Even though it's a tangible item, the courts will say, if all it is a program that performs a mathematical algorithm, merely putting it onto a storage device does not get it over the hurdle. It does not make that which is unpatentable patentable merely because you've stored it on a device. Okay? So that's why I have those dashed lines there. Next slide, number 8. All right. I just wanted to show you by way of block diagram here, who the major players are in deciding whether something is patentable or not, and who the players have been with regard to the evolution of the law. All of you are probably aware that you file a patent application, in the United States anyway, at the U.S. Patent and Trademark Office. It's examined by a human being, an examiner. Usually it's the same examiner from beginning to end, although there could be a change in examiner. But that's not relevant to the ultimate determination of patentability. Within the Patent and Trademark Office, there are also appeal processes. So for example, there's the PTAB, Patent Trial and Appeal Board. So let's say you're working with the examiner, you go a few rounds of office actions and responses, you're not getting anywhere, you can appeal to the PTAB, Patent Trial and Appeal Board. All right? I haven't even represented it on here. But nevertheless, you might get a patent, or maybe you don't even get a patent. You still have an application. You go through that to PTAB, you're still not happy. And although I've drawn arrows here, if you're still in the application, if you're still in the application phase, went to the wrong sheet back there. If you're still in the application phase, your application, after your unsuccessful argument at the PTAB, you could get up and present it to the U.S. Court of Appeals for the Federal Circuit, which is an appellate court. But nevertheless, generally speaking, and I'm sorry, let me interrupt myself there. If instead of just an application, you were able to get a patent, and that patent were challenged, the challenger would most likely bring a lawsuit in the U.S. District Court. Anyway, these three courts, the three top rectangles here, are part of the federal court system. And in case you're not familiar with it, when a plaintiff brings an action in a federal court, they file the action in the U.S. District Court that hears the facts of the case and makes an initial determination on the issue, whatever it may be. In the case of this, it's patentability or not patentability. If either of the parties, either the plaintiff or the defendant, is unhappy with that result, excuse me.
5 o'clock.
You've had a long day. Call to Europe.
Okay, if either of the parties is unhappy with the result at the district court, they can appeal to the U.S. Court of Appeals for the Federal Circuit. The CAFC is the only court in the United States that hears patent cases. Okay?
And are those judges patent competent in any way?
Well, you would hope so. They're not
But
necessarily
there's no
patent attorneys.
requirement.
No, it's not required. It's not required that they be.
Go to the Supreme Court and it could be Gorsuch who's never seen a patent in his life.
Correct. That's correct. Presently on the Supreme Court, of the 9 justices, none of them are patent attorneys. Okay. Okay.
Or
But-
have engineering or science degrees.
Right. They probably don't. All right. Whereas, in contrast, all of the examiners, all the people, I'm hitting the wrong buttons here. Okay. All of the examiners down at the Patent and Trademark Office, they are people with technical backgrounds. All patent attorneys, like myself, are people with engineering degrees. Okay.
Is there a lot of cases that go to the Supreme Court?
I don't know what a lot means, but certainly some have,
Some.
and there are some fairly recent cases, and that's why we're probably here this evening, whether you realize it or not. Okay. So now you probably have heard that there is statutory law, which are laws made by Congress, promulgated by the Congress, and case law, which is law that comes out of the courts as a result of the court or courts hearing cases and making a decision and rendering a judgment. Okay? And so, you hear the phrase, oh, certain justices are activist judges. Okay? That's a nonsense term. Okay? Judge is just doing his job, his or her job. They're listening to the case and rendering a decision. They are not activists in any way, unless they're outside their court being activists. Okay.
That's a related issue. How sticky is res judicata regarding patents?
The Supreme Court can always change its mind. Okay. Res judicata meaning the obligation of a court to recognize or honor past decisions. Okay. And courts are obligated to do that. However, now to fully answer your question, as you're probably aware, in the United States there are many district courts, okay? And so a decision by a district court here in Connecticut is not obligated to necessarily follow decisions by district courts or even circuit courts in California, in the Ninth Circuit, okay? And similarly, the circuit courts in the Northeast are not obligated. In fact, they're to follow the law that may have been decided in California. And oftentimes there are conflicts in decisions where the courts have come to two federal courts, two appeals courts have come to what appear to be conflicting decisions. And that's an excellent opportunity for the U.S. Supreme Court to then get involved and try to somehow either harmonize or overrule, either harmonize the laws or harmonize the decisions or overrule one of the two cases. Okay? But nevertheless, back to something I suggested earlier, or said earlier, there are a lot of people, a lot goes into thinking about these cases. It's not just that, down at the bottom, that a court just whittles and rushes through or bubbles up from the application process up to the U.S. Supreme Court. Between those two entities, there have been a lot of people involved in arguing the merits of a patent or a patent claim or invention, okay? So now, somebody, I think it was Roger, it's Roger, right?
Yes.
You had asked something about, are there a lot of cases in the Supreme Court? And there have been several cases in the last decade or so. Big ones that you might have heard of are State Street Bank, which is from the late 1990s. Okay, that was a case where the court recognized that inventions that involve business methods could be patentable. Okay, you might have heard of the Bilski decision or Alice, which is a relatively recent Supreme Court case. But there are other Supreme Court cases also. But we're going to mention, in fact, it's here on this page right here that I've set forth a chart of several of the cases that have been important in the last several decades in the evolution of the law with regard to patentability of computer-implemented inventions. There are others besides these, but in this table here, just in case you're not familiar with the notation, in the left column, the first column, I've identified the case by its name and its citation. If you were going to go onto the internet now and put in that citation, you would get a hit for that case. You would get a hit where where among the hits that you got would be the actual decision from the U.S. Supreme Court. All of these, 1, 2, 3, 4, yes, all of these 5 cases that I've listed here are U.S. Supreme Court cases. So the dates are also indicated, 1972, 78, 81, 1910, and 2012. So, and then even on the next page, if you want to sneak ahead, on page 10, there's yet another case, the Alice case that I mentioned earlier, 2014. So I don't know if that's a lot or a little to answer your question, Roger, but cases do make their way to the Supreme Court. Anyway, I've selected these several cases because they tell some or include some significant developments. The easiest thing for me to do at this point is to go through each of the 5 cases and read what I've placed into the table. For the first case, I'll just refer to it as Benson. The claimed invention was an algorithm for converting binary-coded decimal numerals into pure binary form. Mathematical algorithm, Jason, okay? It was found to be ineligible for patentability, and a comment that I don't recall whether this is my own comment or whether I lifted this from the case, but it's most likely that I lifted it from the case and maybe paraphrased it a little bit. Simply implementing a mathematical principle on a physical machine, namely a computer, it should be is not a patentable application of that principle. So I have a typographical error there. So again, taking your mathematical algorithm, as clever as it may be, as important and useful as it may be, merely putting that algorithm onto a computer does not make it patent eligible. It is deemed to be an abstract idea that just happens to be executed on a computer. Next, Parker v. Fluke. Mathematical formula for implementing alarm limits in a catalytic conversion process was found to be ineligible. Okay, so again, read what it says here. It's a mathematical formula for computing the alarm limits. It was the formula itself that the applicant or that the patentee, the applicant sought to patent or the patentee sought to maintain. The prohibition against patenting abstract ideas cannot be circumvented by attempting to limit the use of the idea to a particular technological environment. So here, in that case, it was not merely that the inventor had an arithmetic algorithm, but he says, I'm going to use that algorithm to compute something, all right? So he limited his algorithm to some type of calculation, but he was not successful. And the idea is just saying, hey, the invention is still an algorithm. It's just that I'm going to use that number to calculate an alarm limit. Well, that doesn't get you over the hump either. Diamond v. Deere, computer-implemented process for curing rubber. Now, you'll notice this one is eligible. right? Because it improved an existing technological process. Well, that was because in Diamond v. Deere, the invention did not merely calculate a value or calculate a time to advance a rubber curing process, but rather part of the whole method itself involved the actual manufacturing of the rubber. Okay, so in Diamond v. Deere, and I'm doing this, unfortunately people who are listening can't see, I'm illustrating an invention that includes a mathematical process, but the method, the claimed method, also includes more than just the mathematical algorithm itself. Bilski v. Kapos from,
Excuse me.
yes sir.
Okay, now, this computer implemented process, was it actually controlling something, or?
I don't recall.
Okay, or we just have an algorithm, I'm a little confused here.
But to answer your question, I don't recall
Okay,
whether the method itself involved a computer that actually controlled something. For example, controlling actuator or a conveyor belt or something like that. That, by the way, that would almost certainly be patent eligible. The method may have involved a computer doing something and then a human being thereafter taking some action in accordance with a result of a computer process. But if you're really interested, plug that citation into the internet and read these things are very readable, okay? They're not in Old English or anything. The U.S. Supreme Court cases are really quite, I shouldn't say easy. They are, you can comprehend them quite easily, okay?
And there's the full text.
Yes, yes. Some of them are quite long though, but if you want to learn about the law, they're worth reading. Okay, Bilski was a method for hedging against financial risk of price fluctuation. I assume all of you have an idea of what hedging is, okay? It's ineligible because hedging was recognized to be a fundamental economic practice, long prevalent in our system of commerce and taught in any introductory finance class. So, earlier on, I was, I guess about 5 or 10 minutes ago, I was illustrating. You may have a claimed invention, and we'll look at the prior cases that were settled, okay, or prior history, okay? And in the Bilski case, the U.S. Supreme Court's recognized, and probably some of the lower courts as well, as, hey, this claimed invention is really being directed toward, we're trying to claim something we've been doing, we, society, have been doing economically for probably hundreds, if not thousands of years in the form of hedging. So, Bilski was found to be non-eligible subject matter or ineligible subject matter because it was classified as being similar to or little more than a practice that has been, or a method or process that's been in practice for at least hundreds of years. By the way, these the first 4 rows here were specifically computer implemented inventions. But I've included this bottom one, Mayo, which is not computer implemented per se, but rather involves pharmaceuticals or biological processes. A method for measuring metabolites in the bloodstream in order to calibrate the appropriate dosage of thiopurine drugs in the treatment of autoimmune diseases. And so read it again, read it to yourself, but nevertheless the method involved measuring something in the blood, and based on that measuring, or that measurement, advising a doctor to take some particular action. All right? Now you might say, hey, that sounds similar to the computer implemented process for curing rubber, okay? But apparently, the methods for determining metabolite levels were already well known in the art, okay? And the process at issue amounted to nothing significantly more than an instruction to doctors to apply the applicable laws when treating their patients. So, Mayo is different from Diamond v. Deere because Diamond v. Deere, although it used a computer, the process itself was unique. Whereas in Mayo, the process that was being executed was not new. It was similar to, or maybe identical to, processes for measuring metabolites that had been done in the past. And it was merely coming up with a particular number that was allegedly the new thing, and then based on that number, advising a doctor to take some particular action. So I saw a couple of hands up. Okay.
Now, if I took this method.
Which method are you talking
The one at the end, the metabolite method.
I'm sorry, which
Measuring
Mayo.
metabolites.
Okay, Mayo.
I was actually thinking more in terms of maybe an insulin pump and sticking an electrode in the bloodstream. But anyways, if you took this method and created a box, a computer-based box with a sensor that you could stick in the bloodstream, I could patent the box, right?
The way you've described it now, it sounds like a patentable subject matter. And again, hold on. No, these are good questions, but let me get through these slides, okay? And we're going to look at a flow chart, okay, in a couple of slides.
The interaction here, this is a great topic you're
Okay.
lecturing on.
Well, I'm glad you're enthusiastic. But, well, in fact, let's hold that one, and we'll run it through this flow chart that we're going to see in a few pages from now. Yes, sir.
The first three are a long time ago. How much relevance does that have? Because I know
They could
things
be
have
from-
changed a lot, right?
It doesn't matter. It's the concept, it's the principle that is still the same. Although technology, you say a long time ago because of the 1970s, okay? But although technology has advanced since then, and even patent law has evolved, the concept is still the same. And the U.S. Supreme Court or any court if law is even that was established in the 1800s is still valid law unless it's been overturned. Okay.
Or change. Yep.
Change or revised. Yeah.
The fact these are all V or V's, whatever, means these made it through the patent office, right?
You mean
They were
Parker v. Fluke?
They were
V
challenged.
means versus.
They were challenged in court later, but they made it through the patent office.
Yes, that's correct.
They were issued.
These are things.
They were all issued.
I believe, by the way, I believe all of these were. Bilski, I don't think was issued as a patent, and I don't. But I don't know. I don't recall. Okay. I've read through them, and I get to the point where it might, when I'm reading the opinion, it might be a patent or it might not. But for me, for what I wanted to do, I didn't really care whether it had issued as a patent or not. Yeah. The point here is still the same. We're in each of these cases, whether it was an application that never issued as a patent or a patent, there is a patent claim. All right. Whatever its legal standing was not relevant to me as I was reading these cases. Okay. Yes.
Who are the two parties in the cases?
Usually it's an applicant or the owner of the patent. Oh, not the owner, the inventor was the applicant, and the commissioner of the U.S. Patent and Trademark Office. For example, Bilski v. Kapos. Kapos was the commissioner of the U.S. Patent and Trademark Office. Okay. Here it's two parties. So this is almost for Mayo, two parties. So that's definitely an issued patent then, and it was a plaintiff and a defendant, not the commissioner of the U.S. Patent and Trademark Office. Okay, that answers your question? Okay. Next, slide number 10. Alice. Okay. A computer-implemented scheme for mitigating settlement risk, i.e. the risk that only one party to a financial transaction will pay what it owes by using a third-party intermediary. And anyway, in this case, I don't remember if it was Alice or CLS. I don't remember which one of those were the owner of the patent, but they were the third-party intermediary. They wanted to act, or at least their method, their computer, was a computer-implemented intermediary between two other contracting parties, and They wanted to be the agent in between that would secure the transaction and make sure that the appropriate party got paid. It's been around for hundreds of years. There have been maybe thousands of years. The idea of having an intermediary. Anyway, the claims at issue are drawn to the abstract idea of intermediated settlement, and merely requiring a generic computer implementation fails to transform that abstract idea into a patent-eligible invention. Again, this idea of settlement risk or mitigating the risk is similarly to Bilski, is a fundamental economic practice. Now, I'm mentioning each of these things and summarizing each of the cases, just briefly summarizing them, so you can see a general trend here. At least with regard to several of these cases, it was merely implementing something on a computer does not make or transform a patent ineligible concept into patent eligibility merely because it's on a machine. And mathematical algorithms are not patentable, and economic or basic fundamental economic practices is an example of an abstract idea or non-patentable subject matter. So,
John, I've got a basic question.
yes, sir.
What is a mathematical algorithm?
Versus a series of instructions in the computer.
I'll tell you what I'm thinking.
It doesn't have to be
in 1987, Bracewell gets a patent for the Hartley transform implementation, and it's granted. And I'm wondering, why isn't that just a mathematical algorithm?
I'm not familiar with the patent, but that's a good question. But I will say that that patent claim might not be patent eligible today. It might not be. I'm not saying it is or not because I'm not familiar with it. But we take a look at it and we could run it through this flow chart here and see, and then we could argue about it. But anyway, this flow chart is an illustration of. Let me tell you how we got this flow chart. Okay, in the Alice case, 2014, the U.S. Supreme Court considered those 5 previous cases that I showed on the prior slide. Okay, in the table. And it referred to those cases when considering whether the claims in Alice should have been found patent eligible or not patent eligible. And back to that, the diagram that I have where I had the U.S. Supreme Court at the top and the U.S. Patent and Trademark Office down at the bottom. After the U.S. Supreme Court decided the case, well, the Patent and Trademark Office had to come up with some kind of procedure for implementing the decision that the U.S. Supreme Court had made. And the U.S. Patent and Trademark Office came up with this flowchart. Okay? So, they refer to it as a 2-part test, even though there's 3 decisions there. But this will be consistent with the things we've been talking about, or I've been talking about for the last half hour or so. In step 1 of this flowchart, we ask the question, is this, or given a patent claim to some invention, is the claim directed to one of the 4 M's? Is it a machine, a material, an item of manufacture, or a method? If the answer is no, if it's not one of those 4 things, if it's not one of the 4 categories of patentable subject matter, exiting to the right there, the claim is not eligible subject matter. So, if it is a claim directed toward, I should have come up with an idea before I walked in here. I don't have an example off the top of my head of something that is not a machine material.
You found a new plant.
Okay, fine. A new plant, something that occurs in nature. Yes, a new plant. And I found the plant. I didn't invent the plant. I didn't manufacture or create the plant by a hybrid of 2 existing plants. Okay, via asexual reproduction. But yes, I find a new plant. It does not qualify as one of the 4 M's therefore it falls off to the right. It's not eligible subject matter. But let's assume that you do have a computer implemented invention, and even your invention, Roger. Your invention, by the way you described it earlier today, and I don't know if we recorded at that time, but could you just briefly, in one sentence, tell us what it is again? Just one sentence, say it loud so the
So it's a
mic can
machine
hear.
that drives itself along a single cable through the air.
Okay.
Self-driving.
A machine that drives itself along a single cable through the air. So, by definition, a machine, is there a computer in it, a processor
Yes.
with some software? So it's executing a method as well, all right? So your invention at least falls into two patentable, two of the 4M categories. Arguably, it could be including a third category, a storage device that stores the program that controls the computer. If the method itself is novel and not obvious, and you're trying to get a patent on the method that's employed by your processor. But at least your invention covers or falls into at least two of the 4Ms. It's a machine and and a method, possibly an item of manufacture. Okay? So, if it falls into one of the 4Ms, you fall down through the yes path. And so, the question then, is the claimed invention a judicial exception? Is it a law of nature, a natural phenomenon, or an abstract idea? Well, let's not, for purposes of talking about this flow chart right now, let's not worry about details of that. Let's just say we can make a decision. It's either no, not one of those judicial exceptions. And by the way, the plant is a judicial exception, okay? All right? And so, if the answer is no, it's not one of the judicial exceptions, then it is eligible subject matter. So just by way of example, let's say that I invented this chair, okay? This chair is an item of manufacture. So the chair, step one, is it one of the 4Ms? The answer is yes. Is it a judicial exception? No, it's not an abstract idea, it's not a natural phenomenon, and it is not a law of nature. So it would fall off to the left side there out of the no exit, and it is eligible subject matter. But let's say that we find that our invention is a judicial exception, such as Jason's idea earlier. He described an invention which is a mathematical algorithm being executed on a computer, all right? Mathematical algorithm, all right? So is it directed to a machine, material, manufacturer? Well, it's a method, So falls down to yes. Step 2A, is it a judicial exception? Well, for purposes of this discussion, I'm going to say yes, it's an abstract idea. Mathematical algorithm is an abstract idea. It gets to step 2B. So this is the new thing. This is where all the activity is now. The intellectual capital is being put. Significantly more. Is the claimed invention significantly more than an abstract idea? So that illustration I made earlier, where I said, here, I'm sorry for the people who are just listening, okay? Here I'm illustrating the mathematical algorithm, and I'm going to add to that something more beyond the mathematical algorithm. The claim is going to have something more. Well, that something more, if it's deemed to be significantly more, the answer is yes, then it will be recognized as patent eligible subject matter. If it's not significantly more, if it's just...
Doesn't significantly sound rather subjective?
It certainly does. Yes. By the way, the question was, I don't know if the recording device can hear you.
Yes, please let them hear my skepticism.
The question was, isn't the word significantly isn't it a subjective term? The answer is yes. A lot of terms in law, particularly, well, even statutory law, but even case law, are that's where the arguments are made. What's an abstract idea? I'm not going to answer the question exactly. What is an abstract idea? What does it mean for something to be significantly more. If we draw a continuum, okay, on one side is not significant, the other side is significant. Where we have a continuum, at what point does it change over? Is it a binary world? Probably not. There are arguments where, that these additional features in the claim are significant or not. This is what we argue about every day in the patent world. Okay, so more information about each of those steps. I'm on page 12. Flowchart, step 2A, judicial exceptions. What are some examples of abstract ideas? Well, examples of abstract ideas include fundamental economic practices, methods of organizing human activity, an idea of itself, and mathematical relationships and formulas. These are things that the courts have found have deemed to be abstract ideas. So the definition, what's an abstract idea? Well, the definition is evolving. And here are just several examples where the court says, okay, in our opinion, a fundamental economic practice is an abstract idea. So I've listed four examples of abstract ideas. Mitigating settlement risk, that's the Alice case. Hedging, that's the Bilski case. Items 3 and 4, I don't have cases for them, but creating a contractual relationship. Intuitively, you can say, hey, that doesn't sound too technical, okay? That sounds like maybe even a fundamental economic practice. Contractual relationships have been around for thousands of years. Item number 4, using advertising as an exchange or currency. Well, I intentionally included item 4 here because many people who, and even clients of mine who are coming with ideas where they want to obtain a patent, often those ideas involve advertising. An app that evaluates human behavior, and based on that behavior sends a person a discount coupon to get beer down at the discount store or something like that. Well, those kind of things have gotten to the point where they're not patentable subject matter. Okay, so using advertising as an exchange of currency. Next page, 13. Step 2B, what is significantly more? So here are examples of limitations, and by the way, the word limitation means a feature of a claim, a limitation in a patent claim. Examples of limitations that are not significantly more. 1, mere instructions to implement an abstract idea on a computer. Well, that was the Benson case. Example, simply implementing a mathematical principle on a computer is not significantly more than an abstract idea. Item number 2, or example number 2, simply appending to the judicial exception well understood routine and conventional activities previously known to the industry. That would be either the Parker case or the Mayo case. Example, using a computer to obtain data, adjust account balances, and issue automated instructions.
That related to Mayo and which other one?
I'm sorry, number 2, just by way of example, Parker and Mayo are examples of simply appending to the judicial exception well understood routine and conventional activities previously known in the industry. Example number 3, adding insignificant extra solution activity. Okay, again, I'll say Mayo is similar to that as well. In Mayo, as you may recall, they measured the metabolites in the blood, and then the computer or the process advised a doctor to take some action or not action, or some specific action based on that level of metabolite. But by way of example, merely gathering data in conjunction with a law of nature and abstract idea. Let me just elaborate on this number 3. Adding insignificant extra solution activities. Well, let's say you have a computer and and there it is. It's executing a method. All right, and we won't even limit it to a mathematical algorithm. We'll just say that it's doing something, okay? Well, we're not going to transform, and let's say that that doesn't qualify as patent eligible subject matter. We will not be able to transform that to patent eligible merely by saying, oh, we have some other activity happening outside the computer. For example, we're receiving inputs on one side of it, and we're putting the output to a display, or even putting the output on a map, or putting the output on a printer, okay, or a recording or anything. Because they call that post-solution activity. Putting the output in some already well-established format does not contribute or does not add significantly more to the otherwise abstract idea. Example number 4, generally linking the use of the judicial exception to a particular technological environment, or it should be or field of use. Another typographical error. Limiting hedging to the use of commodities in energy markets. So that's similar to Bilski. But anyway, generally linking it to a particular technological environment. That was also one of the other several cases. I don't recall which one. The Parker v. Fluke, okay, with the alarm limits. All right. So again, on these past 2 pages, on page 12 and page 13, I'm showing you some examples where courts have found something to be examples of abstract ideas. Here on page 13, examples of limitations that were not significantly more than an abstract idea. And then on page 14, examples of features that were deemed to, yes, be something significant, qualify as significantly more. The examples are: 1, improvements to another technology or technical field. Example, a mathematical formula applied to a specific rubber molding process. Oh, yes, advance the screen, thank you. I wasn't paying attention. Example number 2, improvements to the functioning of the computer itself. So, if you have, in fact, let me comment on that one right there. Improvements to the functioning of the computer itself. For much of this lecture, I've been drawing a rectangle representing a computer with a memory inside and some activity happening inside that memory. And so you might come to a first conclusion and say, oh, well, if the invention is just a bunch of software running around in a loop in there inside the computer, well, I guess that's never going to be patentable. But certainly one exception to that would be, we have a computer that includes a processor and a memory, a compression algorithm, where it takes a certain amount of information or a certain amount of data that occupies this much of the memory, and through a compression algorithm reduces it so it occupies less storage space. Well, that would be considered an improvement to the operation of the computer. You have more efficiently utilized the amount of the available memory.
So, John, so would that have been a mathematical algorithm if I had made a compression algorithm that, and didn't we get through saying that mathematical algorithms were not patentable, eligible?
But there is significantly more, is that it's going to rearrange the memory and put that, so it has to affirmatively rearrange the memory as well to result in an improvement.
So if I have a big enough head, I can just take common strings and make a code book and do the compression myself on paper, right? I don't need a computer for that.
That's correct. You don't need a computer. If you, Doug, have a big enough head, yes, you could do that. But in my example here, we are not merely executing the algorithm or the mathematical part of it, but taking some memory or some data and fitting it into less memory space as well. Okay? So I'm taking that additional step. So yes, I have an abstract idea in this example. There's the abstract idea of the algorithm, but add to that the actual activity of taking some data, running it through the algorithm, and then having resultant data set that occupies less space in the memory.
Yeah, but that's just a second algorithm, right? You have one algorithm.
No,
and a second one.
No, this is an actual physical change in the memory. Physical change. You have a bunch of ones and zeros occupying this much space, and now you have the same information contained in fewer ones and zeros.
In theory, you could do it in your head if you had an infinite amount.
You could do it in your head, but you wouldn't. But in your head, you would not have resulted in a change in an actual memory device because you don't have an electronic memory device in your head.
You mean a physical change in the?
Yes, it's a physical change.
Physical change,
Change in the memory device.
I get that.
Okay, the electrical properties of the memory device have changed. Okay, example number 3, applying the judicial with or by use of a particular machine. By a particular machine, in my experience, what this really means is using the computer or a computer in cooperation with another type of machine, such as a washing machine or a lawnmower or a self-driving automobile. Okay. Example 4, transformation or reduction of a particular article to a different state or thing. Well, in the physical world, you can certainly understand how a chemical transformation would be changing something from a first state to a second state. But in computers, what the courts have found is in a situation where you have data representing a first thing and putting that data through a transformation process so that the resultant data represents something different could qualify as significantly more. The standard example that I give is a situation where there is a computer that is receiving signals representing X-ray, samples of X-rays, or information or data points of X-rays, and transforming those signals into a resultant image of the object that is being illuminated by the X-ray system. Okay? So, signals in, or data representing signals coming in, and an image on a display going out. It's considered a transformation of real-world information. And then this item number 5, performing unconventional steps. I'm just going to hold off on what that is right now, because I'll admit that one kind of puzzles me, that performing unconventional steps. Yes, sir.
Automakers who this new technology.
Louder, please.
Automakers who are making this new technology, sensors, right? A car is approaching you and the car warns you there's something coming. So that's software in there. Is that being patented?
Possibly, yes, and certainly in cooperation with the. Okay, to answer your question, certainly in cooperation with the sensor, yes, that's patentable. Okay, and possibly even, given that example that I just gave, similarly to the idea of X-rays being processed, or data representing X-ray signals being processed and producing an image, I guess by analogy, a sensor receiving signals representing objects in the real world and processing it and putting out some kind of alarm, because arguably the software is evaluating the signals to determine whether the thing that's being sensed is a snowflake or a bear in the road, okay? And you would want to make a decision based on that difference.
And in some cases, it makes its own decision by applying your brake. Right?
Well, then certainly that's interacting with a particular machine, okay?
Yes, so that's patented.
Yes.
Wow.
Okay, so page 15, examples. Now, so I've got, but by the way, these examples I want to mention right now. Everything that I've been talking about today is available online. Even these specific examples. These examples that I've taken are from a document that I think I mentioned at the end. Yes. Let's jump ahead to page 20, the very last page, okay? The USPTO has lots of publications, but they have one called their standards or guidelines for subject matter eligibility. And it's relatively easy to find it when you go to the USPTO website or just doing a general search. Subject matter eligibility, US Patent and Trademark Office. You'll get a hit. And you'll find a document that discusses everything I've been discussing today, including that flow chart and including the examples that we're about to talk about. So if you're really interested in this, that's and it's easy to read document. It's not 1,000 pages, it's 15 pages or something like that. Okay? So I'm not going to read through each and every word here, but example number 1 is a method of distributing stock quotes over a network, to a remote subscriber. And then I've highlighted 5 steps, A, B, C, D, and E. In brief, A is receiving stock quotes, B is filtering, C is generates a stock quote alert, D formats the alert into data blocks, and E transmits the alert, the formatted stock quote alert. Okay? You can read the rest of the words on this example if you want to do so. But I want to move ahead to the next page where we're going to apply the flow chart. We're going to consider the steps in that flow chart. Step 1A, is the claim directed, and I hope you can recall this. And again, I'm referring to the flow chart on page 11. So if you want to tag page 11 while we're doing this. Is the claim directed to a machine, material, item of manufacture, or method? The answer is yes. It's a process. Claim 1 is a method of distributing stock quotes. Okay, so therefore, on the flow chart, we proceed down from step 1 to step 2A. Step 2A, is the claim directed to a judicial exception? Okay, well, the steps of receiving, filtering, formatting, and transmitting stock quote information can be performed mentally. So, at least in the first instance here, the claim is therefore directed to an idea of itself. All right? Again, consider the big head. The guy with the big head can receive some data, filter it, format it, and transmit it. Transmitting is is insignificant post-solution activity. Okay, so the answer is yes. Therefore, we proceed from step 2A to step 2B. Step 2B. Does the claim recite significantly more than a judicial exception? Well, although the claim includes a transmitter, or transmitting, transmitter receives and sends information over the internet, the microprocessor performs generic computer functions, example, comparing and formatting. So these components are just performing their regular, routine, conventional operations. Therefore, no. Claim 1 does not recite significantly more than a judicial exception, and it would be deemed to be ineligible for patentability. Okay? But now, go to claim 2. And on claim 2 here, claim 2 is very similar to claim 1, but I have written in presented in italics the additional features that are included in claim 2 that are not in claim 1. This way we can do a comparison. I'll tell you ahead, claim 2 is going to be found to be eligible. So it's these italicized limitations that have elevated claim 1 from, or the claimed invention as presented in claim 1, for something that was ineligible to something that would be deemed to be eligible. So, on page 18, we go through the first step 1 and step 2A. We'd come to the same conclusion as we did in example 1. It's directed to step 1. Is it directed to one of the 4 M's? Yes, it's a process, it's a method. Therefore, it qualifies at least as far as the statute is concerned, that's 35 U.S.C. 101, it qualifies as patentable subject matter, okay? However, step 2A, is the claim directed to a judicial exception? Well, just like in claim 1, yes, there is the judicial exception. There are the steps of receiving, filtering, formatting, and transmitting that can be performed mentally. So the examiner will say, yeah, got an abstract idea here. Then we get to step 2B, and we address the question, does the claim include limitations that recite significantly more than the judicial exception? Well, here, this, and again, let's go back to those italics on page 17. And the italics read, providing a stock viewer application to a subscriber for installation on the remote subscriber computer. Okay, so that, by way of example, providing an application to an end user who puts the application on their cell phone. And then the last, down the bottom of the claim, wherein the alert activates the stock viewer application, which is in the cell phone, to cause the stock quote alert to display on the remote subscriber computer and to enable connection via the URL to the data source over the internet when the wireless device is locally connected to the remote subscriber computer and the remote subscriber computer comes online. Maybe I should have explained some background first here. Assume that your cell phone is off or not online, okay? And the purpose of this invention is to specifically issue an alert to me when my cell phone comes online. So the analysis that's presented on page 18 down at the bottom says that this invention addresses an internet-centric challenge of alerting a subscriber with time-sensitive information when the subscriber's computer is offline. It transmits an alert to activate a stock viewer application, which causes the alert to be displayed and enables a connection of the remote subscriber's computer to the data source over the internet when the remote subscriber's computer comes online. This solves an internet-centric problem that is necessarily rooted in computer technology. And this is where they use the phrase unconventional steps. Yes, sir.
If Claim 2 had been written,
Louder?
If Claim 2 had been written as a dependent claim, would it have therefore been made ineligible?
That's a good question. And again, we're assuming that everybody here knows what an independent claim is and a dependent claim. So let's say, for Doug's example here, that we had Claim 1, and then Claim 2 reads, the method, it is a method, right? The method of Claim 1, further comprising providing a stock viewer, comma, wherein the alert activates, etc. So Claim 2, in this example, would qualify as patentable subject matter because it would have introduced limitations that were significantly more than the mere abstract idea that was presented in Claim 1. Okay, you were going to say something?
I was going to say they're not dependent.
Louder so they can hear you.
They're not dependent. Claim 2 can take Claim 1 and move it to a different level and become patentable.
That would be correct.
Right.
Okay. So that was a good question. And by the way, did everybody, that's kind of going off onto a tangent as to what the significance of a dependent claim is. But that shows that kind of illustrates the point. Is if you have an abstract idea in Claim 1, there it is, I'm illustrating it, but you have your significantly more. Well, you could put that significantly more into Claim 1, or the independent claim, and that would be patent-eligible subject matter. Or, similarly, just to make the point, let's say you have an ineligible Claim 1 because it is only an abstract idea that does not include significantly more. Claim 2, the method of Claim 1, further comprising significantly more, means that Claim 2 would be patent eligible. The way to cure this problem in an application would be to amend Claim 1 by including the subject matter or the recital from Claim 2, thus making Claim 1 patent eligible subject matter. Okay?
And the key is significantly more.
Correct. That is the key to all of this. Significantly more. And by the way, And I'm glad you phrased the question that way. Let me see if this is how I'm gonna present it on the next slide here. Yes, where I have my recommendation. Now, as a patent attorney, I argue these things regularly. I argue is not, maybe that's too strong a word, even though that's what I do for a living, is I argue whether something qualifies as patentable subject matter or not. And I could, when responding to a rejection of a claim from the Patent and Trademark Office, I could go to step 2A and try to argue that the claimed invention is not an abstract idea. It's not directed toward, for example, a fundamental economic practice. My experience, I've never been successful in that argument. And again, let me make it clear what I'm talking about. Back to the flowchart on page 211, I'm sorry, on page 11. And again, I'm sorry, again, I'm assuming everybody here has some experience with patents. So, patent application's been filed, I've received an office action. Claim 1 is being rejected, all right? Being rejected as being directed to non-patentable subject matter. It's being rejected under 35 U.S.C. 101. One of the things I could do is I could go to this step here and try to convince the examiner that, hey, examiner, you made a mistake. This is not an abstract idea. It's something that, no, I was wrong. I was going to say it's something significantly more. No, it's not a natural phenomenon. It's not a mere mathematical algorithm. You can try to wiggle out over that way and come down to claim as eligible subject matter. I don't think I've ever been successful in that. There is some case law, by the way, that I'm not prepared to discuss this evening, where cases have been found where the invention was found to be not an abstract idea, that the lower courts were wrong, okay? Therefore, you never even have to get to step 2B. But in most of the cases, if not all the cases that I'm working on, oops, I screwed up here. I direct my attention, my energy to this significantly more argument. I try to convince the examiner, or I show the examiner that the claim includes significantly more. And although I had several examples of things that qualify or have been found to qualify as significantly more, and that was on page 14, okay? I found that the best way, or in my opinion, the best way to do it is illustrated here on my recommendations, next to the last page of this presentation, is to describe, yes, so when preparing the application, when talking about your invention, describe a technical problem that is being addressed by the invention. So I don't know what your little, Roger, you mentioned earlier, your device that is guided along a wire. I don't know what technical problem you might have had, okay? Because I don't know that much about I don't know anything more about your product or your invention. But if you're preparing a patent application, I strongly urge you to describe the technical problem, even though there might be a business problem as well. You might really, ultimately, be interested in trying to determine a credit rating for a company. That might be your business reason for doing all of this. But in order to do so, you might have to evaluate a massive amount of data in a plurality of databases. So, perhaps your improvement would be an improved search, a way of searching databases. Perhaps an improved way of searching parts of databases and maintaining an index to certain results, and then searching the indexes, and then ultimately getting to an answer quickly so that you can quickly provide the information that's necessary to develop your credit risk, okay? But even in a situation like that, I'm urging you to identify your technical problem. Even you can mention your business problem. In fact, that's something I'm going to mention here in a moment. I might as well just go right into it. Very often with clients, particularly when I'm talking to a situation where the inventor might happen to be in the marketing department or sales department rather than the engineering department. They very often think and they present to me their invention in the form of their whole product. They show me their whole product. They say, here's the invention. In reality, most of the time, the invention is not that big product specifically, but rather some feature, some operation that's taking place within that product. So, by way of example, although the product is an enhanced method of obtaining a credit risk score, the improvement is a manner of pre-assessing data in a database so you can execute a search more quickly. All right? So, first recommendation, describe your technical problem. And also within your patent application, describe the technical solution that is provided by your invention. My example here, how are you searching faster? Okay? And if you think about it, that means this invention would not be limited to, in my example here, would not be limited to credit risks, evaluation of credit risk. If you have a method of improving the search, the access time of data, that can be applied regardless of the underlying content or meaning of the data. So, your invention, when a client comes to me and says, oh yeah, I have an invention to improve a credit score. In reality, they might have an invention that covers way more, something much broader, a more broad concept, searching, for lyrics or for song lyrics, or searching for facial image recognition, okay? So, think of your technical problem and your technical solution and include those. Actual writing about them in your patent application, and include that solution as part of your claimed invention as well. By the way, this is called the problem-solution approach, or in Europe they call it looking for the technical effect. Europe, the European Patent Office is actually more, I was going to say evolved, but maybe more strict might be the right word, is their test for patentability is different than that in the United States. Whereas in the United States, we are presently looking for significantly more than the abstract idea. In Europe, they want to see a technical effect. They want the claim to recite a technical solution to a technical problem. So, the fact that there are technical features in the claim, such as processor, memory, databases, all that's irrelevant, because that's exists what's called prior art. We just want to look at what is the technical solution. And the reason I'm bringing this up is because most of the clients that I work with are corporations that file applications not only in the United States but throughout the world. So we write our patent applications, or we try to write our patent applications so that they will pass muster in the European Patent Office. Because if they qualify a patentable subject matter in the European Patent Office, they almost definitely will qualify here in the United States.
I just wanted to say we have a hard deadline. They
They
close the library at 9 and they like us.
Okay.
We should wrap it up if you
Okay,
can.
good, yes, I will wrap it up. I'm going down but not up here. The clicker's not.
Are you pressing the wrong
No,
button?
I'm sorry, I was pressing the laser. I was shooting myself.
Is that an invention?
This thing?
No, that what you invented something to hold your jacket there with 4 legs and all, but hold your.
It is patentable subject matter.
Yeah.
Now.
You need a little help there?
Let me just get through the page. I'm on page 19.
Okay.
Yeah, for the people who might be viewing this, get me back to page 19. And I just want to say, draft independent claims that to the technical problem. Now, just some additional information that I haven't listed here or haven't printed on. When a patent application is filed in the U.S. Patent and Trademark Office, and I should come next to the mic, the Patent and Trademark Office does an initial assessment of the application and directs it to or assigns it to an ART unit, ART unit, where each ART unit handles certain types of technology. Well, I haven't used the phrase business method patents, but I'll use that phrase now, just meaning patents or inventions that are directed to business activities. Always end up, or seem to end up, in ART Unit 3600. So, ART Unit 3600 is the big problem in the U.S. Patent and Trademark Office. So one of the strategies when filing a patent application is trying to do something so that your invention is not directed to ART Unit 3600. Now, so the question is, what does the Patent and Trademark Office do when they're considering your application? What criteria do they evaluate when trying to choose the ART unit? And what I've heard, now I don't know if this is actually correct, but this is from talking to other patent attorneys and other people in the industry. We believe that the Patent and Trademark Office looks at the title of the invention, reads the abstract, and then looks at Claim 1, or the independent claims, at least primarily that information, because they're probably not going to read through the whole application, or they're going to try to make a decision through the path of least resistance. So I urge you then, or I suggest, the title of the invention should not be something like method of calculating a risk score, but instead, method of searching a database, okay? So try to use language that is more of a technical nature, emphasizes the technical features. And in your abstract, don't mention the credit score, but instead mention briefly, summarize the technique that's used to search a large database and find the right answer. And in your Claim 1, don't end it with and outputting a credit score, but rather phrase it such that it is directed towards searching the databases using that inventive concept that it is, and obtaining and returning the correct result. Okay? So, that's all I have to say. I'm wrapping it up here. I'm happy to stay. Now, Doug says we have a hard break at 9 o'clock. That's 10 minutes from now.
The ladies like to go home, and they get all pissed off if we stay in the room and keep them from going
Okay,
home.
I'm willing to answer questions until Doug or the ladies throw us out.
Why don't we give it another 5 minutes, and then that's it.
Okay? Any questions?
Thank you.
No, it's too late for questions now.
So this whole discussion was about 101, right?
Yes, that's 35 USC 101.
Right.
That's what we talked about.
So if you have an abstract idea that meets 102 and 103, but not 101.
Happens all the time.
So what do you do? Just forget it?
Or? Even this past week, it happened to be references that were being cited against an application on which I was working. But one of the references, I'm reading it, I'm saying, what happened to this thing, okay? And I saw that a patent issued. I said, how did that patent claim ever get issued, okay? I don't know the answer. It's an abstract idea, okay? And I see there's a patent. It's not, we're not infringing or anything like that. It's not that kind of evaluation. But I'd say, I wonder if that application, whether there was a continuation or a division, meaning what we call children applications. I saw, sure enough, there were 3 children that were filed off of that initial application. And in each of the 3 children, or at least 2 of the 3 so far, the claims were found to be novel and non-obvious. Meaning the claims were found to be satisfy 102 and 103. They were being rejected under 101. The applicant tried a few times to overcome that 101 rejection, just gave up and abandoned the patent. Even though it got a first patent, it abandoned child number 1 and child number 2, even though child number 1 and 2 satisfied the novelty requirement and obviousness requirement. Okay?
You got 3 cards,
Sure.
Okay.
Well, thank you all for coming. I hope you have a good evening. I'd like to have more questions and answers, but I'm afraid that's all we have time for tonight. We've got to clear the room and let the librarians close. Are you going to go to Penny's afterwards? If anybody's interested in going to Penny's, Moses over here says he's going as well. Raise your hand if you're interested in Penny's. Moses, I'm sorry, I'm afraid. No, there's no tape. Sorry.
You're not going. He's gonna talk about something when he's gonna be done.
Yeah, you're welcome to take on.
Yes, sir.
Reminder, I'm still open to surplus odds and ends if they show up.
Oh, okay.